bargaining the motions to quash certain subpoenas. I'd also bring to the court's attention that during that motion to quash subpoenas, certain subpoenas, Ms. Yurdy's attorney appeared, Mr. Partridge, and he made very clear on that Zoom that Ms. Yurdy had absolutely no knowledge of a romantic relationship and absolutely no knowledge.
The state is trying to throw out Mr. Bradley's testimony.
References that he made.
The Trump team just closed out and had a strong case. So the judge wouldn't even allow them to rebuttal. So right now they're trying to dismiss testimony by Mr. Bradley.
Because of the representations she made to him. So, I know that sounds convoluted, but what I would say to the court is,
they reach
Ms. Yurdy told Mr. Partridge, because Mr. Partridge told the court that she had absolutely no information about romantic relationship, and she had absolutely no information as regards to...
If the judge allows them to continue.
She make inferences based, these would be attorney-client privileges or communications then. She's communicating with Mr. Partridge about what her upcoming testimony is. That's why she's hired him, and you're telling me I should infer things based on her communications to him?
Absolutely, because they're not attorney-client communications anymore when he discloses them to the court and everybody else.
Yeah, this is groundbreaking. It's going to be what you call a case study.
There was no request to go in camera. There was no request to go or to
this is the defense trying to
was done with Mr. Bradley.
Look at him.
That would have been the proper procedure.
Got his legs crossed. I'm a body expert. Got his legs crossed.
I'm asking you to infer that her
he's gay. You know that. You know what that means. He can say whatever. And he white.
The testimony of Miss
Check it out.
when
Struggling.
she testified was
struggling real bad.
Vague, very little description when asked in a very leading manner. Is it true or do you know?
He's trying to throw out Nathan Wade's former
2019
co-worker
into the time you were
Mr. Bradley's testimony out.
You were forced to resign from
the judge did not allow them to rebuttal.
She said yes.
The Trump team.
Further, when pressed by Mr. Sadow, he talks about why she believed they were in a relationship. And what was interesting from Miss Yurdy's testimony that they were pretty close friends up until she left the DA's office, that she asserted to the court that on a yearly basis, Miss Willis said, I'm in a relationship with Mr. Wade in 2019. Oh, by the way, I want to tell you again in 2020, because we're in a new year, I'm still in a relationship with Mr. Wade. And again, in 2021,
no,
the assertion is...
Doesn't make sense.
Ms. Willis then went back to Ms. Yurdy.
So listen, man.
Hey, reconfirm me and Mr.
The
Wade
case that's all going on, we're waiting on the judge to make a decision.
Absolutely absurd.
So this is the defense, basically working for the state. That it's not working.
They were in a romantic.
They trying to throw out Mr. Bradley's testimony.
Something he said. He actually asked her, "Do you see him kissing or hugging?" She said yes, but there was no description or qualification.
So basically,
when it occurred,
you know, it's a log fire. Because if Fani Willis is dismissed from this case of Nathan Wade, then the entire district attorney's office is in question. Because the Trump team, you know, put on, you know, a strong testimony and strong evidence to actually drop the actual whole case. But this is live, so we're gonna watch this together. And this is the defense for Fani Willis and Nathan Wade. This is the district attorney's office. This is the state of Georgia right here. That's actually struggling right now. What we waiting on? Okay, they're in the courtroom. You got Mr. Wade. You got Fani. Her zipper in the back, so her dress on right this time. Yeah. We need a ruling. We need to see what he's going to rule, because the Trump team put on a strong case.
Talk a little bit about the standard and the burden here in this instance.
You see how he's struggling to protect them? He has to. He works for the district attorney's office.
Disqualified. And as I was doing a whole lot of research, I came upon.
Okay.
Article,
You're nervous.
From Cornell scholarship reading or publication.
And this is a polished prosecutor. Look how he's
Have
struggling.
been relatively reluctant to exercise their power to disqualify prosecutors for any reason. And that goes along with the standard what the state would submit to the court is that the defense has to show an actual conflict. And in this instance, they have to show
The Trump team proved their case.
that Ms. Willis received a financial benefit or gain and did it based or got it based upon the outcome of the case.
The Trump team found
It doesn't make any
$17,000 worth of
It makes
receipts.
absolutely no sense. And during the 3 days of the extensive testimony of all of the witnesses and the prolonged examination.
Am I the only one that see that this man is nervous?
Multiple defense counsel, they still got nowhere. We're in the same position
Yeah, right.
we were in on Monday. The same assertions that were made on Monday have no answers today as we're before your honor.
They found $17,000
They were
worth of
not
receipts.
able to provide any evidence as to, or to the contrary of Ms. Willis and Ms. Wade's assertions of when their relationship
6,000
began.
phone calls.
There's absolutely no evidence that contradicts that the relationship did not begin
Text
later
messages.
than, or around March of 2022, Your Honor. I further submit to the court because of this failure.
We all know
that
lying. He
their
lying.
assertion or their request that one, the indictment be dismissed. There's absolutely no evidence that the defendants in this case, their due process rights.
I don't think the
have been
indictment should be
harmed
dismissed,
absolutely
but
anywhere.
they should be removed off the
There
trial
was
for
zero
conflict of
evidence.
interest.
Not a single shred of evidence was produced through any of the exhibits or the witness testimony showing how their constitutional rights, their due process rights were at all affected by the relationship that began in March of 2022 with Ms. Willis and Mr. Wade. And because of that, the motion to disqualify should be denied. And Ms. Willis, as the district attorney of Fulton County, and Mr. Wade,
Not very
as the
convincing,
special
is he?
prosecutor assigned to this case, should be allowed to remain on this case and
No,
continue to prosecute the case to the end, Your Honor, until the trial is set by the court and is to begin.
He don't even believe it
The
himself.
issues, obviously, you've heard.
But when they
a lot
make
from
you, they
defense
could break
counsel as to what the issues are for you to, I guess, determine. And here would be the state's contention is that you must find that there's an actual conflict if you were or are to come to the conclusion that you should disqualify.
There is an
Ms.
actual
Willis
conflict
and the
all
district
day.
attorney's office. And looking at
Looking at what? He not even prepared. This is the state.
it's McGlynn v. State, MCGLY.
We bringing up prior cases to try to prove a point.
342 Georgia
But this
Appeal,
is unprecedented. We never had a
170,
case like this
It's a
before.
2017 case.
This
And
will
that
be a case
talks
study.
about the standard of proof that the defense, or the burden that the defense must show and go to show an actual conflict is, they say it's a high standard of proof, which is definitely not a preponderance of the evidence, which is a much lower burden for any party who's trying to meet that standard of preponderance. But it's
You see how you got to be
what
soulless
the
to be
standard
a
is that it's
prosecutor and
high
an
standard of
attorney?
proof.
Soulless.
For both when determining whether there's an actual conflict and when there's forensic misconduct that is found, Your Honor.
Look at that.
And I want to go through.
He can't even get it out.
That defense counsel has referenced, as they argued here today and in their filings. And I guess the bright line standard or the standard in the
You sound like this is a murder trial.
Disqualification is appropriate for Your Honor to be determining in all of the cases as it relates to disqualifying the elected district attorney. Is you either find that there's a conflict of interest or that there's been some sort of forensic
There's a huge
misconduct.
conflict of
Those
interest.
are, I guess, the two areas that Your Honor that is in your purview.
They're in a
when you are
relationship,
looking
and the judge gonna have to
to,
look at that.
resolve an issue regarding disqualification. Now, in a recent case, Levy State, which is
Come on. You see how you're trying to allude to other
I'm
cases?
sorry, Lexus 31.
This is a conflict of
It's,
interest.
February,
And the state is struggling to
2024,
defend Fonnie Willis and Nathan Wade
case
to remain on the
here at our
trial,
appellate courts.
on the case.
And in that case, Justice Pinson wrote that a trial court did not abuse its discretion by failing to disqualify an assistant district attorney absent an actual conflict of interest. And that's the case that,
Conflict of interest is a relationship,
was
period.
ruled on by the Georgia Court of Appeals about a month ago, Your Honor. Now, the cases in which defense counsel
Look at
has
that.
relied
I'm a
on
body
for briefs
specialist. When you do
today,
that, you lying, you're wrong, and
I
he
would
gets
submit
it.
to the court, the sites are misleading.
This is the state.
Are inapplicable, and some of them actually support the state's position.
No.
And what I would say to you
This
is
is
that
going to be a case
defendants,
study.
in many instances, combine language from the multiple cases, and what I would say is misstates the law. As
No.
it relates
See how
to
he's struggling?
what the law, or what is required in order for an elected district attorney and their office to be disqualified. And what I would submit to the court is.
Let's go back to that. Show me how.
Yeah, show me how. Let's see if he showed him how. Check it out. Let's watch this together.
Show you how.
So I think the first one.
Show you how.
Versus the state. Certainly a conflict of interest.
Certainly
or the
a conflict
appearance
of
impropriety.
Uh-huh.
Be the grounds of disqualification.
Yeah. Look at the state.
Huh?
Huh? Huh? Huh? Look.
There are a number of these cases that seem to exclusively rely on the appearance of impropriety.
Wow. It's not looking
They
good.
acknowledge that there's some ambiguity here, that sometimes Whitworth gets cited of Ventura, and we've got this quote that comes up where it's just they only cite to an actual conflict that must be involved. They acknowledge the ambiguity. You're saying there's no ambiguity whatsoever.
I am saying that, and why
Wow.
I'm saying that.
No
why I submit to the
ambiguity.
court
And they
is in
said
all
they've
of those
been in a
cases,
relationship.
They do reference
They got a phone
the
record.
appearance of an impropriety, but they reference that because they also find there's an actual conflict in each one of those cases.
So your position would be your review of the case law. There's never been an appellate opinion that relied only on an appearance of propriety.
As it relates to a prosecutor or district attorney, yes. That is what
It's
I'm
never
saying. What I
happened
would say is,
before.
in
This is
those
a case
cases,
study.
They do reference the fact that there is an appearance of impropriety.
Anytime you write notes,
They
it's
reference
bad.
that
Check him out. Look at the
because
judge.
when you have an actual conflict, there's always an appearance of impropriety. And
Wow.
those are what those cases stand for. And I guess that is the main example.
The state of Georgia in trouble.
What I referenced has.
This the best y'all
they
got
kind
to
of
offer?
combine, the language from separate and different cases.
Sound like a
and
child
tell them
lying
that
to
the
his
standard is
parents.
an appearance of impropriety. And I would submit to the court, that is not the standard. And in my first reading, like Your Honor, I did notice that the cases each reference the appearance of impropriety, but also that appearance arose from the fact that the court found an actual conflict in each one of those cases.
Yeah.
So I won't belabor.
I think the egg came before the chicken.
All of the cases
He's trying to
that
say it
cited.
the other way
But
around.
What I would submit to the court and reading those cases is
Look at
that,
his body language.
I found that there.
The biggest
fell into
case in his
five
life, he's
categories.
sitting up there
That some
nervous.
that didn't concern disqualification at all, some that determined or that were about.
This is a filibuster.
I call it divided loyalty, which is a conflict that arises from representing
Wow.
becoming a
not looking
prosecutor
good.
and having represented the defendant prior to becoming a prosecutor, and then whether there's an actual personal interest in the outcome, and then others talk about whether the defendant was denied a fundamentally fair trial at the conclusion and of the case after conviction.
Look at that big gulp. He lying. Look at him.
And these are some of the cases that defense counsel had cited within their brief that had absolutely no application to the issue that we're here before Your Honor today.
Wow.
The first.
He don't even believe what he's saying.
Has nothing related to the disqualification of anyone.
And I think some of these are just relating to kind of aspiring for broad language about standards to prosecutors. So point taken there.
Yeah, point taken, bro.
If there are more,
You got more?
all right, keep going.
Keep going. What we got?
So as it relates to one of the cases that was referenced here earlier.
Yeah, he bringing up
and
other
is also
cases
referenced in
to try to
some of the
prove his
briefing
point, 'cause he has
by
no
defense counsel
evidence
is,
or anything to
which is the
defend
East State,
Fonnie
287
Willis and Nathan
Georgia,
Wade stand on his trial.
542, and all of the
So
cases.
he's literally
that
filibustering and
fall
going
under
through
this,
other
what I
cases
would
that have
call
some similarities, but this is
about
typically a case study.
a
This is
attorney
historic
who
and never happened
prosecuted a
before.
defendant,
Like the Trump team said,
the same case,
the global
or
community,
similar
this
charges.
is a global
And
laughing
that
stock.
would be
The
why,
state of Georgia is a
the courts
global
were-
laughing stock.
The courts found that disqualification would be necessary because of the relationship that existed between
He said that already.
the client and
He's filibustering.
the person who's being prosecuted, Your Honor.
Check him out. Look at that body language.
And
Look
that
at
series
it.
of slides just goes through what has been addressed as it relates to
Look at him.
the
He's fumbling
standard,
and bumbling. You don't know what he's doing.
that is required when dealing with the issue of disqualification.
This is unprecedented.
And the state would contend and submit to the court that the defense must show an actual conflict in order.
The conflict is being in a
District
relationship.
attorney disqualified.
The conflict is the money laundering scheme. They got $17,000 of receipts.
Willis, in this instance.
Fonnie Willis don't have no
Financial
receipts.
benefit or gain in relation to the outcome of the case.
Yeah, she gave her boyfriend the money,
that are involved.
and he
personal
used
interests.
his card to pay it to her, and she was not honest and said she
where,
paid it back to him with this cash stash that she had,
How much
but she
they're
never
paid
paid
for
it back because she didn't have
adults, for
receipts.
example, is dependent
Zero receipts.
on the outcome of the case. That's how.
And I don't have no skin in the game. I'm just calling it like this was a basketball game.
Here. And I'm submitting to the court, we have absolutely no evidence that Ms. Willis received any financial gain or benefit. The testimony was.
Well, she
that
didn't
Ms.
disclose
Willis
anything.
paid, all of the money back in cash as related to the trips, and it didn't pay back in cash.
She had to say
It was,
that.
All right, let me explore
You
this
see
one a little
that?
bit.
Check this out.
So
Cut him off.
in addition to, you're saying it's only an actual conflict, are you also saying that it's only if a financial interest is affecting the final result, the outcome, that's the only one we should be worried about? Or is it that the prosecution as a whole is what we should be looking at in terms of a stake? So what I'm thinking of, I'm just going to try and come up with some hypos here.
Come on.
What if ADAs are given a bonus for every motion to suppress they win? $1,000 per Fourth Amendment claim they win.
Not looking
Or
good.
an incentive if one of their officers is lying, not to tell you about it, because they want to win that motion to suppress. But maybe that doesn't affect the outcome, because you can win a motion to suppress or lose it, and that doesn't decide whether, it's going to be a guilty or not guilty verdict. But doesn't that affect the prosecution of the case, if not the outcome?
Yes, I would definitely agree that that would be an instance where disqualification would be necessary and appropriate because it's a situation that involves a contingency fee, and I would submit to the court that it actually does end up affecting.
It could, based on how important the motion to suppress is, right? But if it's immaterial, I don't know. But I guess. So you're saying it's maybe not so much just whether it's a guilty or not guilty dismissal, no process at the end of the day. It is actually the conduct of the prosecution that should be looked at.
There we go.
The course of the prosecution.
Correct, as it relates to how it affects the prosecution, which I would submit to the court ultimately is going to affect the end outcome of the case. If you have a contingency fee based on winning or
Judge threw him a
motion to
slow
suppress,
pitch.
and if you win, you get a bonus, as Your Honor referenced. I think that
It's
is
like he
ultimately
missed
going
it.
to affect the
That was a
end outcome of
screw.
the case because, as Your Honor just said, if there's an instance where an officer is lying, or where there isn't a good faith to go forward with that motion.
Look at the lady
prosecutor
looking
will go
at him
forward
over there.
regardless,
Boy, you know
because
you lying.
of the contingency fee, which not only affects the prosecution at that point of the proceedings, but ultimately is going to affect the entire
They're talking
case.
about
Because
contingency
if,
fees
in
that
order
does
to
not
win
include
a
this
motion
case.
to suppress
So
her,
this is
I
what
guess
they
the
call
motion would be
filibuster.
denied, and the evidence wasn't suppressed, knowing that they didn't have a good faith basis to go forward, affects the ultimate outcome of the case. So I think it's twofold, as Your Honor has referenced. I think it's
For the record, there was no
part of
receipts
the-
brought in
the
for the
procedure
cash
of the
exchanges.
proceedings,
Absolutely
would definitely
zero to defend
qualify for
themselves.
reason necessary to disqualify a prosecuting agent. The ultimate outcome of the case
See,
being or hinging upon
he's defending the prosecution's agency, which is the district attorney's office. This is why he has to do what he's doing.
So, so getting into the language again, what you just had up there with greater amusements and amusement sales. Greater amusements is one of those. You refer to the appearance of conflict as dictated. Why do you think that's dictated? I think the quote from that one is, it guarantees at least the appearance of a conflict of interest. Why is that dicta? It seems very central to the holding in the case.
Because I don't disagree.
He bringing in the appearance
that
of it.
case, an actual conflict was found, and the
Okay.
appearance.
They didn't find that.
They didn't find it.
I would.
He messed
I would
up.
disagree with
See?
you. I would.
He's disagreeing with Your Honor.
My
Think
reading
about
of the
that.
case is that an actual conflict was found, but because of that actual conflict,
There was no conflict found.
an appearance of impropriety was seen, and that's the reference.
And aren't we looking
or
for an
not the
appearance
reference
in this
to that
case, which is there and which is
in
valid?
relation to the argument that an actual conflict is required.
Yeah, his mind's scrambling right now. Check him out. That's why I went live. He don't even know where to go.
Series of cases, Young, that was referenced by defense counsel, as well as Nichols, these state, are both instances where.
And you see the Trump attorney over there.
Interest in the
He
case.
looking like, yeah, we
due
got
to,
this. He's
the
just watching the show now. They know they got
situation
this.
And where, at one point, they were opposing parties. And of course, there's a personal interest of state.
And Fonnie Willis
as it
is
relates
not
to,
only on trial with Nathan Wade, the
and
entire
opposing
district
party
attorney's
in a civil
office is
claim,
on trial.
Which are what both of those cases.
That means
are
the state of
referenced,
Georgia.
which shows that there's an actual conflict of interest that relates to the personal gain of the specific prosecuting agency.
And what do you make of Nichols' reference to, it's an older case. Sometimes the language can be, what we're not accustomed to seeing, but there's, they refer to the metaphor of Caesar's wife. And generally when that's used as a ethical standard, that's something that goes beyond just an actual conflict, right?
Uh-oh. Good
Isn't it
question.
beyond reproach, getting more into appearance world?
Do you really want to go down that road is what the judge is
Is it
saying.
getting beyond?
No, isn't getting into the appearance
Right.
aspect of things when we're
Judge
talking about
telling-
Caesar's wife.
He's going down the wrong road.
Beyond that, based on the language of the holding in that case, where it literally says that the individual had a personal interest in obtaining a fee by forcing a settlement in the civil case and using the criminal case as leverage. So that's not an appearance of impropriety. That is an actual conflict of interest,
Which
in
has
arises
nothing to do with
because
this
of the
case.
individual's personal stake in the end outcome.
And I say that
of
because
the
this is a case
Your Honor.
study.
So
This is
that's-
historic.
That's how I
Never
would
happened again. So
differentiate,
depending on how the judge
I guess
responds,
the
we're going to see this case as a reference moving forward. So this is
The
historic.
standard or the burden that must be shown, and why the state would submit to the court, and the most recent
And
ruling out of the Georgia.
When the other lawyers are just watching the show, that means that they got him because that Trump lawyer just sitting there chilling.
So
and he's
let's
over
get
here.
through these series of slides. You've heard all about Whitworth.
Man, when your jaw doing that,
So I go back to
you know something wrong.
Earlier.
He went back to the original. He couldn't find nothing else.
The grounds in which a district attorney can be disqualified is where a conflict of interest is found.
That word keep
and,
coming up,
where there's,
conflict of
forensic
interest.
misconduct that is found. Those are the two grounds. That are
Conflict and
to,
misconduct has been
be,
found
I
and
guess,
proven
are within the
by
purview of the
Trump's
court as it
team.
relates to the issues here. And again, I go back to the most recent case that was Justice Pinson wrote about, and that it
He went to a Supreme Court
failed to
opinion.
disqualify the assistant district attorney absent an actual conflict of interest. I think the language there is very clear, and I think it's very controlling.
Wow.
And I think it's purposeful.
Lawyers
I submit to the court
are
because an
suspect.
actual conflict of interest is what is required in order for a district attorney to be disqualified because the
Look at that
cases
goat.
make
meeting
very
line.
clear and through the precedent relating to this issue that a disqualification of a district attorney is the last, for lack of better words, ditch effort that should be exercised as it relates to the court.
We agree.
Ensuring certain conflicts
But there's
that may
been
arise.
a conflict
I
of
think the
interest.
case law is very clear that
No
every
case
effort is
where the
supposed to be made,
prosecuting attorney's office
instead of, or, I
was
guess, in
sleeping with
lieu
the
of,
hired prosecutor prior
disqualifying the district
to.
attorney unless
the
the
case.
actual conflict of interest is what's found, Your Honor. And it can't be cured.
Look at him. He's still looking. Look at him.
So, what I would reference.
You need
to
some
the court,
water.
As was brought up earlier in Lyons v. State, 271 Georgia, 639, a 1999 case where it talked about a theoretical or speculative conflict will not impugn a conviction.
He's bringing up a theory. This is not a theory. This is a theorem, meaning the fact was proven that they was in a relationship.
Are not enough for anything to arise to an actual conflict. And what I would submit to the court as well, that goes to the fact that what has to be shown is an actual conflict. If it's speculation.
Is there any qualifier there though that
Check him
that's
out.
in the post-conviction context?
So
We're talking about, so, you know.
He asked what the
confident
outcome
evidence.
was to the case that he just mentioned.
I've wondered how much import to give that sentence when we're in a pretrial realm. That's assessing whether to overturn the conviction, and usually that's being, kind of an entirely different standard where we assess as a totality. Was there a fair trial? Is there harmless error? I know there's no harmless error when it comes to disqualifications, but just a thought. If you have any reactions.
No harmless error when it comes to disqualification.
Pretty on point in the sense that
Yeah, Your Honor's on point.
it's found
That's why he a
that,
judge and not an attorney.
If the trial court either applied the wrong standard or should have disqualified the district attorney, it leads to an automatic reversal, like you said, and it goes back to the trial court. And I think that is
Wow.
very enlightening in the sense that
Fonnie Willis got the district attorney's office on trial.
Actual conflict
Wow.
shown, and the fact that it can't just be theoretical.
She didn't help us
or
either.
assumptions
With the Grey
that
Goose
lead
and,
to the appearance
it's a G, I'll give him a G. She didn't help herself.
Appearance of a conflict that would lead to.
Exactly. Don't help your boy out. There she
I
go.
guess maybe I'm borrowing coming from.
Oh man, she gave him a note. If you don't sit your butt down.
You get different treatment pre-trial and post-trial. Post-trial, they get more of a pass unless you can show some issues, and I'm wondering if that same principle applies here with disqualification.
Well, and I would.
I don't have the answer to that.
But what I would also say, and I don't remember the exact line, but I know.
You need to remember.
In Judge McBurney's order, he does address some of the concerns as it relates to the standard as it's applied post-conviction versus pre-trial, during pre-trial issues. And what I would say to the court is that
He's struggling. He's struggling.
I didn't think the state was all that.
Fonnie Willis had to give him some notes.
the
He's
analysis.
struggling right now.
well, what I'm citing.
Legal analysis.
And to be for the record, her
Well,
zipper in the
I'm
back
citing
today.
what you specifically referenced as to the standard that is to be applied pre-trial and post-trial, whether it makes a difference. And what I would say to the court is the answer is no, as it relates to the speculative nature of the allegations or the
Man, that's a
claims
wrap.
made by defense
The only way the
counsel,
judge can
as it
rule
relates
the other
to
way, unless they gave that man a back.
whether a conflict actually exists, Your Honor.
Because I don't think, there's no way they can continue on with this
What I can't
trial.
do at the moment is point exactly to the page.
What I can do at the
At
moment
the end of
is point directly to the
the
page.
state's argument, I can give you
At
the
the
page
end of the
number. It relates
state's
to
argument.
Judge McBurney's order.
I think I know what you're talking about.
He know what he's talking about.
Just the appearance standard.
Yes.
All right, okay.
Further, in Lamb v. State.
You need to go hurry
Georgia,
up.
41, on page 42, it's a 1996 case, where the court says, nevertheless, the conflict must be palpable and have a substantial basis in fact. A theoretical or speculative conflict will not impugn a conviction which is supported by competent
It's
evidence.
not a
Now, I
theoretical.
understand,
This is a theorem.
as it
This is a
relates
fact.
to,
They were
the
together.
post-conviction factor.
Not denied,
The
but
statute
when
is being
is the
imposed
question.
conviction, based on Your Honor's earlier inquiry, but I would submit to the court that as it relates to the issue of disqualification, that the standard is the same, whether it's post-conviction or pre-trial. In Bloomfield v. Bornstein, which is 247 Georgia 406, the 1981 case. In that case,
1981.
It says the appellees have not shown us a case where a per se rule was applied.
We'll be back to
disqualifying an attorney on the basis of
1862, Abraham Lincoln.
propriety alone. Georgia cases cited by the appellee do not stand for the proposition
Oh,
that the trial
man.
judge is authorized.
Hey, I'ma say this
to
again.
disqualifying attorneys solely on the basis
This will be
of
a case
appearance
study.
propriety,
This is a
which,
historic
further goes to the
situation.
state's,
We've never seen this
submission to the court
before.
that
So
the
its
standard
references
is,
may
that
be
an
used
actual
or not,
conflict
but
must
this
be
is
shown.
a
And that
historic
conflict,
case study.
that arises shows that there's a personal stake of the district attorney as it relates to their personal financial gain that's being alleged.
And he just realized he basically talked himself into what Nathan Wade and Fonnie Willis
The
have
case
been
has been
doing.
referenced by all parties here today. Whitworth v. State 275 Georgia, Appeal 790 to 2005 case. In that case, it says Whitworth's complaints are largely based on speculation and conjecture. Applying any evidence standard to the record, it is clear that the trial court did not abuse its discretion in denying Whitworth's motion to disqualify Morgan based upon his personal interest in his conviction.
Aren't we past the speculation and conjecture aspect
He
of this?
said past speculation.
The original and the core of the financial allegation was that there is a relationship and that money has changed hands.
Wow.
There's maybe still an open question of
When?
where the ledger stands.
Okay.
I think it was conceded that that balance could run in one way or in the district attorney's favor.
Either way.
Is that contested?
Yes. What's not contested is that a relationship did develop between.
And the purchases were made back and forth. That's the state's position.
That is the state's position, but they were made back and forth. The purchases were made back and forth, either to equal the money that was spent by one party or the other, and if that
She didn't
wasn't
pay him
done,
back.
cash was exchanged in order to
With no receipts,
equal
none.
the costs that were paid by either one of the parties.
Right. But that's a facted issue, whether it was
Right.
split
If,
even.
if
or
this
whether it
was
goes
a fraud case,
a little bit one way or another, or
Money
whether it's
laundering
all the
case.
way $10,000 one way or another. That's a facted issue as a result of the hearing, but it's no longer just the theory that money changed
Told
hands,
you,
no
it's a
longer
theorem.
speculation or conjecture.
it's a fact.
Well, I agree that money
He's-
actually
he
changed hands
agreed.
is not speculation and conjecture, but whether that money that changed hands had any financial benefit or gain to the district attorney. that
Yes,
is all
she gave her
speculation and conjecture.
boyfriend
I would submit
a
to the court,
$650,000
absolutely all
contract,
speculation and
which
conjecture
led him
to
splurge and make it rain for her.
embarrass the district
Come on,
attorney
man.
based on
It's
some
like
of
a
the
stripper
questions
giving
that
you
were
some
asked,
money,
absolutely nothing
give you
to do
$10,000,
with
and then you
proceedings
go
in
to the
case.
strip
For
club and
example,
give it all
the
back
lien
to her.
on her alleged
Come
house
on, man.
that was highly irrelevant, had nothing to do with the proceedings and the exchange of money between the district attorney and Mr. Wade. And the point of that line
The
of
state not
questioning
doing too
was
well.
to, again, embarrass and harass the district attorney in a way that was
She
very
embarrassed
public,
herself
and in a way that was to impugn
because of her
character
moral
as it
turpitude,
relates to
which is grounds for disbarment.
question
Moral
in front of the court,
turpitude,
in front of
corruption,
anyone watching
grounds for
the
disbarment.
proceedings as it unfolded.
Because the judge rules in the Trump team's
And the
favor,
language
the
in
entire district attorney's
Whitworth,
office is
I
in
would
question.
Again, submit to the court requires that an actual conflict must be shown, which is
The
why
conflict has
the
been
reference
shown.
to speculation and
Money has
conjecture
been changed
is again
hands with no
a
ledger,
reference,
and it could go
because
either way. It can run
speculation
up
and
or run
conjecture
down.
leads to or equals an appearance of impropriety, not necessarily an
Man,
actual
she
conflict.
should have got Johnny
which,
Cochran, rest in
since
peace.
The court is what
She
is
needed
required based
somebody
on
to help
the case
her.
law.
This guy ain't help. Look at that face. Look at his face. He looking like Bradley. He about to start crying like Bradley. Look at his face. He don't know what to do. You keep looking. Fine.
So
Oh,
in
okay, go ahead.
State v. Sutherland, which is 190 Georgia.
You
Appeals
found another
606,
case. Dang.
1989 case. And it says what prosecuting officers should see.
He's
that
just
no
gonna take
unfair
all
advantage
this
is
time. I
taken
wish
of the
Maxine
accused
Waters was
if he
here
is not a
to recuse
judicial
her time
officer.
for this brother.
Those who are required to exercise judicial function in the case are the judge and the jury. The public prosecutor
jury.
is necessarily a partisan in the
So
case.
it's the judge's
If we were compelled
discretion.
to proceed
He
with
will
the
make a
same,
ruling.
circumspection as the judge and jury.
No
there will
jury.
be an end to the conviction of criminals.
This is
which
not a
goes
criminal
to the
case. This is a
premise
misconduct
that
case
the,
and
appearance
motion
of
to
impropriety
dismiss.
is to,
No crime was
apply
committed.
to judges, not prosecutors. Because if that standard was to be applied in the manner in which the Sutherland case is referencing, then there would never be a criminal prosecution because the state is always going to appear biased as it relates to
Wow.
any justice for the victims. Or
Yeah, he's
righting,
saying the judge
the
gonna
wrong
appear
as it relates
biased
to,
if he
the
rules
crimes
in
which,
favor of the Trump
defendant
team.
is,
Wow.
been indicted or accused of.
That's disrespectful. Here they go, giving him some more notes. Look, look, look. Like you messing up, bro. He went down the wrong street. Finally gave him some notes, and then the other prosecutor gave him some notes.
I guess the evidence that Your Honor saw and heard during the last couple of days, 3 total days of testimony.
I think she told him to close this thing out.
You heard from Ms. Yurdy, who the state would contend is a disgruntled former employee. You heard from Terrence Bradley, also someone who is a disgruntled former partner. The text messages and
yeah,
the
they're
state's
trying to discredit that man. That man
show
was
that
up
he's
there
vengeful,
crying because he about to
for
lose
his
his
own,
bar license.
Testimony here, sitting before the court, that all he did was speculate, and any information that he had and garnered and then passed on to Ms. Merchant was mere speculation. I believe he
It wasn't
said that over and
speculation
over
until he
again
was under
when
oath.
asked.
He was crying
if
because,
he had
you know, these
personal
evildoers in
knowledge,
high places, they'll pull up.
My recollection
They'll
is,
come see you.
around 15 times, he said he had absolutely no personal knowledge of a romantic relationship between the DA and Mr. Wade. You also heard from the
Not
special
true.
prosecutor, Mr. Wade, a former judge. You heard from the 80th governor of the state of Georgia, Roy Barnes. You heard from the first female.
The governor
elected
didn't
district
take the
attorney
case.
of Fulton County. And you heard from her father, who was a 40-plus year practicing attorney in good standing when he left the practice of law. And
Who was
what
living
I
with her
was
other
report
boyfriend,
is
DJ.
that Miss Yurdy's testimony was nothing more than inconsistent at best, based on what I
So they're going for
referenced to
character.
the court, earlier
Just
as
for
it
the
relates
character
to
of the
the
testimony.
representations that were made by her counsel prior to.
Are those in evidence? Would his responses during a motion to quash, which weren't subject to cross-examination by defense attorneys,
In which they didn't even cross.
weren't even part of the evidentiary record of the hearing? Again, I'm just kind of puzzled by that.
Trying to
You
help
didn't
him out.
ask the question of Ms. Yurdy, what did you tell your attorney before coming here? And then we could have dealt with privilege issues and whatever else.
Right. But they didn't do it. And now he's
I mean, I
stuck.
would agree with the court, it's not in evidence, but it was a statement by
See the judge like,
an
man,
officer of this court
he trying to help
to
you
the court during a hearing related to
because he's
her
a Fulton
testimony
County judge. He don't
and,
want this to
how
go
to
in the
proceed
wrong
with
way.
her testimony in this hearing. But it's clear that what was represented as to why
They didn't even
she
cross.
would not have, I guess, be an appropriate person to testify was that she had absolutely no knowledge of the romantic relationship. That was the basis
But they didn't
of
cross.
why her counsel was saying that she shouldn't have to testify, that she
So
wouldn't be
then
compelled.
under that theory, if accepted, where did the incentive arise between Monday and Thursday for her to completely change things around?
Exactly. 5.
Where did the incentive arise?
She was fighting
See,
so
when you
hard
ask a
to
question-
avoid if we're going down that road you propose, she was fighting not to come in here and testify at all.
Why he didn't hear that yet?
And then she comes in here and testifies.
What happened?
Why would you testify the way she did if she didn't want to testify so strongly?
look at that.
If we're going down this road of trying to just gauge her interest.
Wrong
and-
road again.
and
Judge
she-
trying to
I don't know if I'm
turn him in the right
following that theory.
direction.
And I can
You
appreciate that.
got he leaning up on the table.
The reason she didn't want to testify in the court is because this is an incredibly public forum where she would have to testify
That's
against.
speculatory. That's your opinion. You should have asked her during cross.
And I think the change, I wouldn't qualify as an incentive. What I would qualify is ultimately when she was forced to testify, right,
See,
a
that's what I
motive,
should've done.
and a bias as to why she testified in the manner in which she did. When asked by Ms. Merchant as to the reasons for her leaving, she kind of danced around the issue. And then
Like you
as
doing
Ms.
right now.
Cross asked her about whether she resigned or forced to leave, she was fired. She came out and said she was given a choice. You can either resign, but either way you're leaving. You're fired, or you can resign in a manner in which, she wouldn't be officially fired. And when she's trying to get future employment and things of that nature. So I would submit to the court that there's absolutely no incentive. An incentive is not why Ms. Yurdy's testimony changed, or the state would contend her testimony changed. But it was the reason she testified the way she did was because of her bias towards the DA, which gave her motive to
But
what the state
there
would
was
contend
no
is be less than honest. before the court.
cross-examination on this stuff.
And I would.
But if we're going to draw inferences based
Boom.
on her fighting the subpoena, Why would she have fought it if she had such a bias and wanted to say these untruths?
She didn't want to testify.
Because she didn't want to come on national television.
Just
and
like
have
Bradley
to,
didn't want to testify.
be exposed to the things.
She had credible
that-
information. That's why she fought the subpoena, and she didn't want to go on record, just like Bradley didn't want to go on record.
I don't know anybody who wants to testify before a court in a normal trial, a normal proceeding, but one of what I would qualify as.
See how he's struggling?
high-profile
See how he's
nature,
struggling with that?
Where everybody would be able to
What?
watch and learn at what she has to say as it unfolds
Nah.
in the courtroom. And I further submit to the court there
She
is
wasn't on
a
trial.
reference to she left the DA's office in the text message that were submitted in, I believe, what is it, Defense Exhibit 39, that it's because she released confidential information in the DA's office, from the DA's office, that led to her firing, that she wasn't.
Just because it's more conversational.
Shut
I
it down.
appreciate it. I know I might be getting you off script, so I don't want to use up all your time.
See how the judge don't want to get him off script? You see that? Help him out, Judge.
Next, Terrence Bradley, and I believe the one thing that.
Talk about Terrence Bradley
the
now.
state and defense counsel can agree on, that he was less than honest at times during the proceeding and during his testimony. When pressed or asked by Mr. Sadow why he was fired, he basically chalked it up to a dispute between partners.
Yeah.
In a business. But when pressed by Ms. Cross, it was clear that that wasn't the reason. And what I would submit to the court, what has been referenced by defense counsel as baffling as to why the state would go into such a topic area.
And he works for the state.
As all counsel has when appearing before the court, it's a duty of candor. And when Ms. Cross knew she was going to have to cross Mr. Bradley, she knew he lied. And she had a duty of candor to the court, in the state's opinion, to expose that. More importantly, it goes to his credibility. And the statements.
So they try to discredit the witnesses
had
that
been represented by
testified.
defense counsel that he
Because they don't
allegedly
have
had
nothing
made
else.
in the past. It was important to bring that to the court's attention, because when a witness is testifying, the court is assessing their credibility and determines whether to believe the veracity of the statements made by the witness or not. So that is the most important factor when determining whether somebody is telling the truth or a lie. Furthermore, he
Talking about Bradley.
reluctantly, when pressed, finally admitted that he paid off the assault victim. It
went into his personal
started with an
background.
escrow account, led to he did pay off the.
He was supposedly
victim in that case.
sexually assaulted an employee.
He testified over a span
He
of
wasn't
3
even
days.
on
Like
trial.
in reference to the court, he must have said 15 times that he had no personal firsthand knowledge as it relates to the relationship between Ms. Willis and Mr. Wade. More importantly, when pressed by counsel, he could not pinpoint a time in which he knew that the relationship occurred. There were many instances in which
He
he described
refused to
that very
pinpoint. He
well
could have, but he
followed within,
refused to. That's why
the
he was
time
crying.
frame that was testified and by both Ms. Willis and Mr. Wade as it relates to the relationship beginning or transitioning into dating in March of 2022 and into the end of the relationship in August or the summer of 2023. And as I referenced to the court, the statements that Mr. Bradley made, the state would contend are inadmissible hearsay.
So
as it
the
relates
entire
to the
issue is
statements,
when did they start
that,
dating?
He was
That
pressed
was
and
the
asked
whole
about
issue.
what Mr. Wade
Smart
told him,
testimony
because Mr. Wade
saying it was
never
back in
confronted
2019
with those
and
statements.
2021.
In order for impeachment to be
They're
proper,
saying it
he
happened
must
in
be confronted with the
2022.
specific statements that are alleged to have been made in order to impeach him. Again, Mr. Bradley had every motive to lie. I believe the text messages are.
I think he was forced to lie,
are very
or
clear
he was gonna
as
get
it
in
relates
trouble.
to his disdain towards Mr. Wade, which due to the fact that he was expelled or exiled from a thriving law practice. It was clear from the practice,
Yeah.
and Mr. Wade
He's
sided
struggling.
with the alleged sexual assault victim, which is clear he assaulted her due to the fact that he paid her off.
He was not on trial for assault. He was on trial to testify
And
when
as
the
I
relationship
referenced
started
earlier,
between Fonnie Willis and
yeah,
Nathan Wade.
Ms. Merchant represented to the court that Mr. Bradley had personal firsthand knowledge.
Trump's attorneys over there laughing at him. Look at it. They're over there laughing.
And that he would be able to basically be an impeaching machine. I think Your Honor referenced him as the star witness when you were addressing the claims that were made by Ms. Cross in relations to Ms. Merchant's representations to the court. And what I would submit to the court is that all Mr. Bradley's representations as it relates to whether or when the relationship between Ms. Willis and Mr. Wade began, and whether they cohabitated, because that was a promise that was also made, that he would be able to impeach the investigators as it relates to cohabitation, was mere speculation, gossip, and innuendo.
Well, 12,000 text messages and 6,000 phone calls.
Here's my guy, and we can correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Directly overheard, which ones are we talking about specifically?
Well, essentially, that kind of seemed to be all of them. You had said Allen, Bond, Young, and then the investigators, Hill, Green, and Ricks, could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
Affirmative, yes.
In reference to your question, the unequivocal answer was yes.
Affirmative,
And,
yes.
When Your Honor is looking through the text messages, I would submit to the court that the text messages don't even say or indicate what was represented to the court in relation to the good faith basis for this motion to disqualify as it relates to the testimony
the text
and
messages
the
now.
ability to impeach witnesses through Mr. Bradley. What's been referenced by all counsel is Mr. Bradley's assertion of absolutely as it relates to whether the relationship existed prior to Mr. Wade's hiring. And the question in itself involves speculation because it asks, do you think it started before she hired him? And he says absolutely. He doesn't say he knows. He doesn't provide any context as to how he knows.
If you say, what's your,
And in
is your
these
name
text messages and in
Sean
his
Glover? And I say,
testimony in court,
absolutely. Come on, bro.
the source of his information
He's the source.
was unclear.
He's the source.
What is what I would
He
say. to
says
the
the
court.
source of Bradley's information is unclear. Mr. Bradley
to
is the
a lot
source,
of things.
and he was friends with Nathan
And other
Wade.
than the
Nathan
one
Wade was
conversation
pillow
that
talking to his
allegedly
board.
occurred, between Mr. Wade and Mr. Bradley, and I would submit to the court that that conversation never occurred. That would be the state's contention.
In theory, the state contention said they
because
never had a
that
conversation.
was not confronted, or Mr. Wade was not confronted with that conversation, and that is evidence.
He's saying the conversation never existed because
I need to say
Mr. Wade,
no,
while
as
under
to that
oath, wasn't
conversation not
confronted with the
existing,
conversation.
Because
But Bradley
based on the
testified after Mr.
representation
Wade.
made by defense counsel, it would be clear that that would be a conversation that would have been relayed to, because it wasn't privileged, as Your Honor found, that would have been relayed to Ms. Merchant. And if that conversation happened, you better believe that would have been a conversation that defense counsel would have confronted Mr. Wade with and against. And the reason they didn't do that was because it didn't exist.
He's saying the conversation didn't exist.
Again, you heard from Mr. John C. Floyd III, the district attorney's father.
Wow, the Trump team over there
as you
laughing
heard,
at
he
him.
was a well-respected member of the legal community for over 40 years.
He's talking about
But the importance
Fonnie
of his
Willis'
testimony was to provide the court with corroboration as it relates to
Cash.
the years leading up to the relationship that transitioned into dating between the district attorney and Mr. Wade. What he testified to is that he moved into her South Fulton home
question is
in
not
2019.
if, the question
The
is
evidence
when.
of his moving into that home at that time was his Georgia driver's license, official government document. He further testified that not only did it wasn't that just Miss Willis and himself live at the South Fulton home.
Her boyfriend
but
DJ
that
was there.
He often would see on numerous occasions the significant other of Miss Willis that was not Mr. Wade. He referenced that that person had a nickname of
DJ.
Deuce.
Oh,
and
Deuce,
he kept a lot
my
of his
bad.
belongings
He was a
in the
DJ.
garage of Miss Willis. He specifically said he kept a lot of his disc jockey equipment is how he referred to it.
Just remember, Deuce put out a video, said that she was cheating on him with
Mr. Wade
Mr. Wade.
at the South Fulton home that is owned by Miss Willis. He
And
made
when she
clear that
stopped living there,
he lived in that home with Miss Willis and Miss Willis alone, other than her two daughters who would occasionally visit that home until
they moved.
after February of 2021. But
When they
what,
moved.
precipitated,
February 2021.
He soon
She moved out of the house.
Miss Willis to what I would reference as a safe
To the
houses,
house where
protection was
Mr. Wade
a protest
visited
that occurred before
often.
her home in February of 2021. He then expressed to the court that Miss Willis moved in the spring of 2021, and that due to these threats that were taken very seriously, he had only seen his child 13 times.
Yeah.
He said.
So he never
in
been
reference
to the house
questions,
that Mr. Wade would
by defense
frequent.
counsel that
Or Deuce.
were in a. I mean, I'm just going to be
Exactly.
straight up with the court.
Go ahead.
They were trying to make Miss Willis a liar. What is how I would submit to the court, in the sense that
She was not
testified
honest.
that she was concerned for her safety and her family's safety,
Which has
included
nothing
her
to do
father
with this case.
and her daughters, and that Mr. Floyd remaining in that home kind of rebutted all of that, made it so it wasn't true. But he testified that he stayed in the home because it was a home that she had.
But he
put her
testified
blood,
that he
sweat,
didn't
and
see
tears
his daughter
and,
only
was
13
able to
times
die.
in a full
And that he
fiscal
stayed in the
year.
home because there was constant officer presence. He told the court that he bought extra security equipment. He even went as far to tell the court that he slept in different rooms on different nights because he felt his safety was in such a concern. So I would submit to the court that line of questioning was done in an attempt to discredit Miss Willis, but failed. Would be how the state would characterize it. Then he testified about the first time that he did meet Mr. Wade, which is in 2023 here at the district attorney's office, and he talked about.
He said he found out about the relationship when we did.
How he kept cash in his home and why Miss Willis kept cash in his home.
Yeah,
and what I would, what the court should take note of is
Come
the
on,
state
give us
didn't
something.
ask Mr. Floyd about the cash in his home. That came out through the cross-examination of defense counsel.
Because he wanted to
So
defend his daughter.
there was I guess, an implication that Mr. Floyd only did so due through his preparation with the state and his hearing and seeing news articles and clips related to the testimony that had occurred prior to him. But I would submit to the court that it's telling that information came out through questions that were asked by defense counsel.
Which has nothing to do with this case.
Gives credibility to the statements that were made. And he further explained as to why he taught his daughter to keep cash in the home as it relates to financial independence and having a safety net. It was further testified that he had multiple safes and that he gave Miss Willis his first lockbox, or her first lockbox, for
Yeah, she's a
situations,
district attorney.
as
It
she
should be for
described,
money
when
or
she
her
was
guns
testifying.
and for classified
And what I want to
documentation.
make clear
Make
is
it
during
clear.
Ms. Willis's testimony, it was pressed about the cash and where she kept it. Did it
So he's
follow
confident
her,
about
where
this
she
part.
laid her head, and things of that nature, trying to
He's
further
confident about this
discredit
part.
the practice that she had as it relates to keeping cash in her home and why she had the ability to pay cash to Mr. Wade and other people and for other situations. And what I would
But there's no receipts from where the
what the
cash
court
came
should
from.
take note of is that there was no evidence that controverted that at all.
Because they didn't want
Where
to
was
go
the
down
evidence
that
that
road.
controverted Miss Willis's claim and practice of keeping cash in her home? There was none. In fact,
It would have been a waste of time.
it was
Because we black folk know that. We all keep a cash box.
Father, Mr. Floyd.
If you don't, do.
Furthermore, you heard from former Governor Roy Barnes, and his testimony was significant and important because how I would phrase it, Your Honor, is it debunks.
Let me, on this point.
Yeah, cut him
I
off.
think you might have had a more recent opportunity to review his testimony than I have.
Yeah.
You say on the slide that she was the first choice to lead the prosecution. Was that actually his testimony, or was his testimony that he was asked to come aboard? Did he use the words that he was asked to lead?
Yes, it would be, that's my
He
recollection.
refused
was
to
asked
lead. That's
lead
what the issue
prosecution.
is.
He was asked to.
And he like, nah,
take
I'm not.
He was asked to fill the position that Mr. Wade is currently in, which is the lead prosecutor. It was said in that way as well.
They asked
as
a
it relates
former
to the
governor to
testimony of
lead,
Mr.
and then they
Barnes.
went to
So I
Mr.
think
Wade,
Be very clear.
which is
My recollection is that he said lead, but what I can submit to the court that I know he also said that he was asked to fill the position that Mr. Wade is currently filling for the state of Georgia, which is the
At
lead
that
prosecutor.
time, as
so they didn't get the first draft pick.
prosecutor.
They got a free
Right.
agent.
Yeah, the special, I guess, yeah, as the special prosecutor to lead the investigation, which led to the ultimate prosecution that we're here before Your Honor today. He also indicated that the reason he turned that job down was because it didn't pay enough. He said he had mouths to feed at his law firm, and that he also didn't want
$650,000 wasn't
to,
enough. He knew he couldn't win this case. That's what
he lived that
his
for
issue
the
was.
years in which he was the governor of Georgia. Furthermore, he confirmed the qualifications of Mr. Wade, which I still find quite interesting and confusing as to attacking Mr. Wade's qualifications, in that it's almost as if
He never
Mr.
did a
Rowland's
felony
counsel
case.
is asking that the
Personal
state
injury
put a
attorney law firm.
prosecutor on the case that she
So that's
sees
like
to be
hiring Sweet
more
James.
qualified to attempt to convict her client. It's an interesting argument, and it's one that makes no sense.
Okay.
Furthermore, if you were to believe the claims and allegations as it relates to Ms. Willis' personal stake in the prosecution, the receiving of financial benefits and gains, then you'd have to believe that she was also dating Roy Barnes, the former governor, and Gay Banks,
No, look at
in
that.
addition to Mr.
No.
Wade. If she has this
Deflection
grand
and distraction.
plan scheme in order to
No.
profit off of the prosecution of this case, because that's what they're saying. Or they're saying that she telepathically or prophetically was able to know that Mr. Barnes and Mr. Banks would turn down the position so she could then hire Mr. Wade.
No, it was
It's
by
ridiculous.
default.
It's absurd.
It was by
and
default.
It's
They didn't take the case.
desperate.
Nobody was going to take the case, but she put Mr. Wade on the case because he would take it. And, you know, this is what transpired out
Your
here.
Honor.
Because the question is, why these credible attorneys did not take this case? That's the
And
question.
embarrassment.
And then the personal
This
injury
slide
attorney
went through
did,
a
which
lot
she
of
happened to be
testimony.
dating,
That should be clear
which had to
there.
be spending money on
There's
her.
evidence that Mr. Banks turned her down, right? Is that part, how's that part of the record?
Come on.
Well,
How's that part of the
I
record?
asked the court to take judicial notices, has been asked
Unless,
repeatedly.
the district attorney testified to that. I don't recall offhand.
Yeah, go ahead.
I will be frank with the court, I don't recall if Ms. Willis testified
don't
to that
recall.
exact fact, but I know that Mr. Banks represented that to the court during Monday's hearing as it relates to the allegations that were made. I understand Your Honor's position as it
I'm just
relates to
trying to make
that.
sure we know exactly what is in the evidence and is not, but.
That's not the evidence.
I think your point is
I
made.
think it's an
Shut it
evidence
down.
of the record as it relates to, I guess, the issues that led up to the actual hearing of this case. So I understand Your Honor's position, but it did come out during a proceeding that was prior to the actual hearing. This slide is just a chart showing kind of the testimony of both the district attorney, Ms. Willis, and Mr. Wade, as it relates to how they met, how or when Mr. Wade became the special prosecutor, when their relationship evolved into a romantic one, talking about the trips in which they took after their relationship.
Let's talk about the
evolved
trip.
into one that became romantic, and when it ended. And
So
when
he's
again,
saying
I
that they
submit
did
to
have
the
a
court
romantic
that
relationship.
those facts were
That's a
consistent.
conflict of interest.
And the only
Whether it happened before or after.
When the relationship started,
Which is
was,
moral
Ms. Yuri.
turpitude.
And what I would bring to the court's attention is that it was represented to the court that Ms. Yuri was a witness other than Mr. Bradley who could bring to the forefront this issue of cohabitation. And when pressed and when asked about it, Ms. Yuri had absolutely no information as it relates to this alleged cohabitation. It was false. She said she had
He's
no
strong on that
information.
part.
She was asked about trips. She said she had no information about the trips. Yet.
But we
she
all
said she
know they went on
confirmed
trips.
that, Ms. Willis confirmed
Whether she
each year
corroborated the
that
stories or
Mr.
not.
Wade and her continued to be in a relationship. 2019,
and
2020,
Willis
2021.
told those
until,
stories about
their
the trips.
relationship ended due to her forced resignation and
what?
splintering of their friendship, Your Honor.
Yeah, okay.
You heard, I guess, several exhibits obviously were
Here we go with the exhibits
most
again.
of them were exhibits that came from the sealed divorce of Mr. Wade.
A sealed
and,
divorce.
Ms. Jocelyn Wade, contracts for legal services, trip itineraries, and the text messages. And I would specifically reference prior to today, the only text messages that were before Your Honor were defense exhibits 26 and 27, which it's the assertion of defense counsel that what those show is that Mr. Bradley had information as it relates to the relationship starting prior to March of 2022, and that's just false. Those text messages do not contain that.
Yeah, okay.
It does not pinpoint, just as Mr. Bradley couldn't, when the relationship
So the
actually
defense
started.
said on that part-
And furthermore, you have the testimony and the evidence of the text messages that it was mere speculation. If you, as Your Honor reviews.
That the calls
full
were
chain of text
alluded to
messages, it is
love-struck
clearly,
teenagers.
Ms. Merchant and Mr.
16,000
Bradley,
text messages.
going
And then he
through
said
what I
6,000
can
calls, and the
describe
youngster
as nothing
said,
else
and I'm
other
not
than
gonna
a
say
mere
what they
fishing
said.
expedition,
And those are what they call
between
booty
the 12th and
calls.
the 1st, because it's asked about certain members of the DA's office who would have information as it relates to specifically, for one, Ms. Young. It is asked whether she would have information, and he had no idea. He said he assumed, he was speculating.
After the fact, after they done pulled up on
That
him.
was subpoenaed in reference in the text
After the
messages.
fact, he said that.
All of that was speculation, and you know it was speculation because not a single one of them testified. That's telling. Because if it wasn't mere speculation, if it wasn't mere gossip, and if it wasn't mere conjecture, each one of those people who were subpoenaed would have been called to testify, like District Attorney Willis was, like Mr. Wade was, in order to be confronted and then impeached by Mr. Bradley. You've heard, obviously, about the phone records, and I have a maybe, because whether it comes into the purview of Your Honor.
6,000
as it relates
phone
to,
calls.
The determination Your Honor is to make as it relates to the disqualification of the district attorney. You also have the affidavit from the employee who works at the winery who confirmed that Ms. Willis did in fact pay in cash up to more than $400. And
So she
I
put
understand
$400
this is
at the
not a proper
winery,
mistake,
cash.
But it's important because that is a witness
Not
who
in
the
Napa.
state didn't go find. That is a witness who went to CNN in order to confirm what Ms. Willis testified to, further giving her statements credibility and credence before the court.
But regardless, they together.
You heard
They was in a
about,
relationship,
Before we move
which
on
is
now, other than the
more
foundational
turpitude.
concerns, would you have a response to the proffer of the cell phone records?
I have, I'll get to that now, I was gonna get to it later.
Giving-
but I
asking
have
him for a
several foundational
response.
Concerns
Go
as
ahead.
it relates to the cell phone records. I don't think I've ever, as Mr. Sadow's motion makes very clear, the state uses cell phone records routinely, and I would agree with that. We use them routinely,
Uh-huh.
but we use them with an expert, and they're always challenged.
Right, so, like I said, in the interest
He
of time,
can't
setting
justify
aside the foundational
the
concerns.
cell phone record,
What you're
6,000.
asking
No,
about.
no, no. But focusing on the substance of them, assuming that it would be admissible in the guise that he's proffered. Maybe you had that further up, but what's the reaction to that?
What's your reaction to the 6,000 cell phone calls?
Initially is that due to the fact that they were analyzed by someone who was a non-expert, the analyzation of those cell phone
Non-expert.
records
Wow.
were not properly peer reviewed. They were not.
This is
it's
his
clear,
reaction to the
from,
6,000 cell
the state review
phone
that
calls.
the normal practices that are used to check the use of which kind of data is being used in reference to the two specific dates. I believe it's September 10th and 11th and November 29th and 30th. The affidavit that is used to say that Mr. Wade remains at Ms. Willis's or in the area of Hateville, because again, during the hearing, the address for the Yurdi condo never came out. It was just that it was the Hateville condo. The actual phone number for Mr. Wade was never established. And the documents that were provided to the state that were certified business
He's trying to
records did not
discredit
have
the
a
evidence.
subscriber page. So we have no idea.
You don't have a
that the
reaction
number belongs to Mr.
to
Wade.
the
And I understand
6,000
Your Honor wants to look past the
cell
foundational
phone
issues, and I can appreciate
calls.
that. But the foundational stuff is very important as it relates to the admissibility of the records.
No doubt about that, but if somewhere, how they were able to survive those foundational concerns, do you have any reaction?
Yes, I do, and I can. I'll
What's your
skip
reaction?
forward so I don't.
What's your reaction? So, what's your reaction?
What's interesting is that the records that were provided were they start in January of 2021 and they go,
Wow.
I believe it's to
That's before the
November
relationship.
30th. I think it's what the 2021, the span of the records. And you heard from all of the witnesses, including Ms. Yurdi, that Ms. Willis did not move into the Hateville address until April of 2021. That was the testimony from all of the witnesses, April of 2021, and that she lived in her South Fulton home from when she met Mr. Wade in October of
What that
2019,
got to do with the
up
cell
until
phone
when she had to
records?
move. And the assertion by defense counsel is that Mr.
Phone
Wade and Ms.
communication
Willis
well
began a
established
relationship
before that.
right after they met in October of 2019. What's interesting and what's telling is that Mr. Wade's handset doesn't once appear in anywhere near the area of her South Fulton home, but they're dating, but they're in a serious relationship. And if you were to believe what the defense counsel says, that they have been in a relationship from October of 2019 up until she moves in April of 2021.
It would have been dumb
a
for
year
him
and a half
to for
or
him
so,
to go to
but
her
he never
house.
once enters the area of her
Because
home.
DJ is living
They
there.
want you to believe
DJ
that
is
that's a
living
lie,
at the
which is
house.
why,
So how
counsel
and why would he go to the
continued
house?
press,
Because
District
Deuce
Attorney
and her
Willis
father's
as
there.
to whether
Come
he
on,
ever
man,
been
don't
to
make no
that South
sense.
Fulton home. Well, this corroborates
Why would he go there?
that
Deuce
that
was
not a
living
lie,
there.
that he had never been to that home.
Deuce was living
And,
there.
It's more than suspect if you've been in a relationship, as they claim, for all this time, but never once went to the house.
Because Deuce was living there. Keep that in mind.
Telling. What I can also
not
bring to the
telling,
court's
bro.
attention in the state's initial review
DJ,
of the
Deuce was
records,
living there.
that from January of 2021 to March of 2021, those times when Ms. Willis did not live again at the Hateville address, she didn't move there until April of 2021. That his handset appears in that area 23 times.
Sure.
Why
How
is
do
that?
you reconcile that with this testimony that was alluded to, I think, by opposing counsel?
She didn't
The
move
reasons
it. She
he gave
had
for
the
being in
spot,
area.
but she
Well,
didn't
Those line
officially
up to
move in until the
23
dates in
times.
question. But the house was there.
You know,
Well,
I think too many reasons for being there, right?
Check it out.
Well, I think that's the point. I would say yes, that is the point. He referenced that that's an area that it was not uncommon for him to be in.
The spot
And
was a
clearly
safe
that is the
house
case
and was
because
not
Ms.
established
Willis didn't
as
live
a
in that area.
resident.
So again, it's further corroboration.
live there? Yes,
as to
okay.
what Mr. Wade.
She was still living in
indicated
the
to
house.
court. And
Deuce
when,
didn't know nothing
I guess,
about the
after
house.
Ms. Willis,
That was a
moved
spot
into
coming
the
from a
condo in
man.
April of
That's,
2021.
hey, meet me at the spot. Let's do our thing.
Now, I want to make clear to the court, both Ms. Willis and Mr. Wade never denied that he had been to that condo before. The specific testimony that was elicited by Ms. Willis and Mr. Wade was that he had never laid his head, was the direct quote, at that condo, which these records don't prove that he laid his head anywhere. If you were to believe the analysis, or if you were to...
That was the spot.
If you were
She
to
had a
give
man
credence
living
to
at her
what
house,
the
Deuce.
non-expert says,
And
as
that
it
was the
relates
spot
to,
before she officially
Mr.
moved
Wade's
out.
handset on in September and November for the 3 to 4 hours that the phone is alleged to have remained.
Yeah, she just
that
looked
doesn't
at the
disprove
camera.
anything that was testified by both Mr. Wade and District Attorney Willis. It was that he visited there. The specific hours of his.
Well, that's crazy,
of their
man. How you a
visit was not
district attorney, now
something that,
you
was
sitting there.
pursued
Man.
during the questioning of both of the parties.
Making us look bad, bruh.
What I
Yeah,
would
bruh.
also submit to the court.
Yeah,
is that if
bruh.
you look at the days.
Yeah, I'm gonna go and cut this in a minute. I got things to do. It's almost 1 o'clock West
The
Coast time.
use, the type of information that is used to make the plots for the longitude.
What if
and
he say, man,
latitude
get that camera on
of
my
the
face?
handset Is data records. It's not voice records.
Man.
It's not SMS.
So I'm gonna have to tap back
It's
in.
data
My
records.
prediction is
And,
the judge is gonna
it is
not rule in
not
their
uncommon
favor,
for an
okay?
expert to
So with that
testify
being
to
said, hey,
the
thanks for
specifically
sticking in
to
with me,
AT&T
man. Y'all
records.
have a good one,
That
man.
actual data
And let me
record
see here. What's
is,
going on?
unreliable
This is the
as it
Fonnie
relates
Willis
to
case, and I
the
just
location
decided to
of the
go
handset
live.
due to the type of information that
The
it
judge is
that
supposed
data.
to
It's
rule
not the voice
today
and the SMS, which I know Your
whether
Honor,
to
as has been
a motion
referenced,
to
is,
dismiss
was a
Fonnie Willis and
prosecutor
Nathan Wade
only
from
here
the
in this
trial.
county, but
And this is the
for,
defense
the federal
that's
government
up here
where
struggling,
this
trying
kind
to
of information
defend
is
his
commonly
job,
used.
trying to defend
So,
the district attorney's
in the
office.
comments
So
that were
literally
made by
the
the
district
court,
attorney's
it was clear
office
that
is in
you,
question right now.
understood
So if
and
they
understand
are
the use of
dismissed,
cell phone
they're
records
facing
as ways to
disbarment,
put somebody in an area,
a whole lot of
and not
things,
in a
so
specific location.
we gonna see. So with
I
that being
also
said,
raised
man,
the
y'all have a good one, man.
as
Peace
it
out.
relates to the
And I will
validity
give a
of the
reaction
affidavit
to
and
the
analysis
judge's
done by,
final
the
opinion
expert,
because he's gonna go
that
on
was
and
hired
on.
by,
So have a good one. Peace out.
Mr. Sadow, is that not once does it reference the fact that AT&T records